In June 2013, Mrs. Katrina A. Parrott envisioned bringing racial diversity into the realm of digital communication after her daughter raised the question, wouldn't it be nice to have emoji that look like the person sending them? With this vision, Ms. Parrott developed an innovative solution and assembled a team to create emoji so that people of all races, gender, orientations, and abilities can express themselves through an abundance of diverse emoji. Mrs. Parrott founded CCI and created the iDiversicons brand, the world's first diverse emoji. Each of 5 skin tones comprises one of African American tone, Asian tone, Latino Hispanic tone, Indian tone, and Caucasian tone. They've also applied for protection from the Patent and Trademark Office through utility and design patent applications. So the short version is that CCI worked with Unicode to include room for these emoji in the Unicode standard, and she submitted this color theory to the world of emoji: fair tone, medium tone, deep tone, dark tone, light tone. CCI was internationally recognized as a creator or the creator of diverse emoji. Here are some of the diversicons or diverse emoji that she made. She apparently had discussions with Apple, trying to get Apple on board with licensing her emoji. She provided them with the icons or emoji. She met with people at Apple, and she even released her emoji app as a featured app on the Apple App Store. Then, shortly thereafter, like a month thereafter, Apple released its own first diverse emoji, the accused products, using the 5 skin tone keyboard modifier palette. I think you hold down on the thing and more icons pop up. And you can see there's different skin tones on the thumbs up, different skin tones on faces. She engaged in more negotiations with Apple and Tim Cook, and then she accuses Apple of copying her emoji. And here's some examples that we're going to refer to later. Look carefully, though. What do you see as the same? What do you see that's different? The iDiversicons emoji, which I'll call CCI's emoji because iDiversicons is just really hard to say. They have strong lines, strong outlines. It has a gradient of color, whereas Apple's have soft lines and have a consistency of color. There's a little bit of a shadow on Apple's knuckles or fingers on the thumb there, and there's no shadow on the CCI emoji. Similar here. Strong outlines on the CCI emoji, soft outlines on the Apple. But yeah, do they look similar? Yeah, they look like people's hands, or they look like people's fist, or they look like people's pointing finger. Pointing finger again, left and right, and down, and up. And here you have a little bit more definition because you're seeing it palm side first. But again, it's the same theme. The CCI emoji have a strong outline and a gradient color, and the Apple emoji have a shadow and softer outlines. Here's the OK hand, here's an ear. You can see that they're similar, maybe even substantially similar, but they are definitely not identical. And so CCI claimed that Apple had willfully infringed on their copyrights, and trade dress, I believe, is also in here. So here's the count for copyright, and here's the count for trade dress infringement, false designation of origin, and then common law unfair competition. Well, what do you think happened to CCI's case? After going through the basic beginnings of litigation, Apple filed a motion to dismiss, claiming that its emoji do not infringe on CCI's copyrights. Let's see what the court had to say about that. Cub Club Investment, CCI, created an app that allowed people to send racially diverse emoji. According to the complaint, when Apple learned of the app, it liked the idea, so much so, in fact, that it copied it. But even assuming the allegations in the complaint are true, the idea is all that Apple copied. Because Cub Club has not alleged the copying of any protectable element of its emoji, the motion to dismiss the copyright claim is granted. And because Cub Club has not adequately alleged trade dress infringement, the remaining claims are dismissed as well. But how could that be? When we look at these emoji, They look very similar. They look substantially similar. Doesn't the substantially similar doctrine apply in a case like this? Not exactly. Copyright law does not forbid all copying, says the court. To survive a motion to dismiss, a plaintiff must allege that the defendant copied enough of the protected expression to establish unlawful appropriation. In making this comparison, one of two standards applies, depending upon the range of possibilities open to someone attempting to implement the idea. Where the range of the possible expression of the underlying idea is broad, a work will infringe if it is substantially similar to the copyrighted work. Think of a book or a play or a musical or a movie or a TV show. There are lots of possibilities. You can do anything. You can go to space. You can go underwater. You can have a drama in a studio apartment. There was even a movie about a guy trapped in a telephone booth. You can do lots of different things. So there, substantially similar applies. But if there's only a narrow range of expression, then copyright protection is thin and a work must be virtually identical to infringe. The copyrighted works at issue in this case are expressions of Cub Club's idea of racially diverse emoji. Each of the emoji described in the complaint are variations on this theme, depicting body parts in certain positions, thumbs up, thumbs down, a fist, etc., in varying skin tones. There aren't many ways that someone could implement this idea. After all, there are only so many ways to draw a thumbs up. And the range of colors that could be chosen is similarly narrow. Only realistic skin colors, hues of brown, black, and beige rather than purple or blue, fall within the scope of the idea. Cub Club's emoji are therefore entitled to only thin copyright protection against virtually identical copying. Remember a few years ago we talked about dance moves, and there was the Millie Rock dance that Millie tried to copyright, and the copyright was denied because you can't copyright short, choreographed dance moves. A longer choreographed performance can be copyrighted, and it's hard to tell if you have a long dance, is that choreography under copyright law and therefore protectable, or is it a dance move? But the Millie Rock was a short dance and it was just a few common moves put together and therefore was not copyrightable. You can't copyright the human body. You also therefore can't copyright things like pointing a finger or giving a thumbs up or making an A-OK symbol. Those are things you can do with a limited range of motion of your body. Yeah, you have a lot of motion, and I can talk like this and make lots of motion, but that doesn't mean that I don't have a limited range of that motion. I can only go so high, so low, left or right, etc., etc. So there's a limited amount of expression you can make with the human body. Therefore, there's also a limited amount of expression you can capture when you are trying to embody those forms in an emoji. This is also known as the Merger Doctrine. There are cases where there is very little choice about how to express some fact or idea, so a copy or close paraphrase may be unavoidable. When a fact or idea and the expression of that idea are seen as merged, the expression cannot be protected. In other words, the idea and the expression merge, and it's as if there's no protection for the expression because there's only so many ways to express an idea. As alleged in the complaint, Apple's emoji are not virtually identical to Cub Club's. Compared side by side, there are numerous differences. Whereas Cub Club's emoji are filled in with a gradient, the coloring of Apple's emoji are more consistent. The shape of Apple's thumbs up emoji is cartoonish and bubbled, while Cub Club's is somewhat flatter. Many of Cub Club's emoji have shadows. Apple's do not. I think the court may have got that reversed. It's Apple's that look like they have shadows, and Cub Club's do not have shadows. Even the colors used are distinct, although both Cub Club and Apple have chosen a variety of skin tones ranging from dark to light. The specific colors vary. These differences are sufficient to take Apple's emoji outside the realm of Cub Club's protected expression. So does that mean that anybody can go use Cub Club's emoji without paying a license fee, or anybody can go use Apple's emoji in a commercial sense, copying them into your own app instead of implementing them in an authorized way. No, it doesn't mean that. The CCI property and Apple's property or copyright protection on those emoji still exist, but they're only protected from exact copying. Virtually identical copying is going to be the standard that the court uses here. And that's it. That's the end of the court's analysis on copyright. They do go over trade dress infringement, and this is only another page long, so let's check it out. To state a claim for trade dress infringement, a plaintiff must allege that 1. The trade dress is non-functional, 2. The trade dress has acquired secondary meaning, and 3. There is substantial likelihood of confusion between the plaintiff's and defendant's products. Let's go through this backwards and deconstruct this. So the standard for trademark infringement is likelihood of confusion for actual customers. If I go into the store and I see 2 different products that both look like a Coca-Cola bottle, one of them is from Coca-Cola and one of them is not from Coca-Cola, how do I tell? Well, maybe the name is different. Maybe the second bottle doesn't have the red label and doesn't have the Coca-Cola script or font, doesn't have the little white swoosh through it, doesn't have the shape of the bottle. If it does have all of those things, trying to sort of piggyback off of the popularity of Coke products, then you might have a claim for trademark infringement. Then number 2, the trade dress has acquired secondary meaning. Secondary meaning is where someone recognizes the shape of the bottle, for example, in the Coke example. If someone can look at all the bottles without their labels on them and say, oh yeah, that's definitely what a Coke bottle looks like, and enough people do that to cross the threshold, wherever that is, then the Trademark Trial and Appeals Board or the Trademark Office will recognize trademark protection in that shape of the bottle. That's secondary meaning. That's what secondary meaning means. If I have Joe's auto body, that's not very descriptive, or actually it's entirely descriptive. It's not very fanciful or arbitrary or suggestive. It literally is an auto body owned by Joe. Then that's what we call a descriptive trademark, and that has the least amount of trademark protection. Pretty much no trademark protection until everybody in the region recognizes that Joe's Auto Body is that shop or that chain. Joe and his auto body won't have any trademark protection. But if Joe opens up his auto body, it gets popular, he makes a second location over here and a third location over there, and he covers the entire eastern side of the state, and everybody knows that when you go to Joe's, you're getting Joe's quality and it's coming from Joe. That's secondary meaning. And what Joe will have to do to get trademark protection is get a bunch of affidavits from customers that recognize that Joe's Auto Body means this particular chain of auto bodies. And then, number 1, the trade dress is non-functional. So it has to be like artwork on the bottle. It has to be the shape of the bottle, but not the shape of the bottle because it needs to be that shape. So for example, a compressed air tank for, just going to the bottle example, a compressed air tank for scuba diving or for industry to use gases and things has to be a pretty standard shape. So you can't just trademark the generic shape of a compressed gas bottle. However, if you added something non-functional, you made your compressed gas bottle, wavy on the outside, like it was encased in a wavy design or something that's totally non-functional and that acquires secondary meaning, you could have trademark protection on the shape of your compressed gas bottle. This was part of the dispute in the still ongoing Elderwood hexagonal box. They want to trademark or trade dress on the inside shape of the box, which has 7 hexagonal holes, or 7 hexagonal holes and rotated such that it creates diamond relief patterns on the edge. And they want to say that everybody recognizes that that's an Elderwood box. If you ever see the inside of that box, then you'll know it's an Elderwood box. We're currently waiting for the Trademark Trial and Appeals Board to rule on Elderwood's summary judgment motion, and I'll have an update for you when I can. Going back to this, the trade dress alleged in the complaint for the emoji is functional. The asserted trade dress consists of the overall look and feel of Cub Club's products, including the insertion of an emoji into messages on mobile devices by selecting from a palette of diverse 5 skin tone emoji. This is functional in the utilitarian sense, as each of these features, the insertion of an emoji into the message and the ability to select the desired emoji from a palette, relates to the performance of the product in its intended purpose. Even the fact of the palette of diverse skin tones is functional, as this aspect of the product, though aesthetic, serves a purpose wholly independent of any source identifying function. The source identifying function can be a little bit confusing. It just means the source of the product, the products or services. Coca-Cola would be the source of Coke. So the trademark is meant to identify the source. The brand is meant to identify this product is coming from one source, and you can connect the quality of this product to that source. Whether it's good quality or bad quality doesn't matter. The quality should be something the customer can connect to a particular source and know that when they buy a product with that branding, that they're getting that quality from that company, and that company is responsible for that quality. You can't build a product for sending racially diverse emoji if the emoji are not racially diverse. Cub Club's allegations that the asserted trade dress goes beyond these functional elements to the look and feel of the product is not enough to save its claim. As a matter of law, a product's overall appearance is functional and thus unprotectable, where the product is nothing other than the assemblage of functional parts. In the absence of allegations identifying non-functional elements of Cub Club's product, such a conclusory statement is not sufficient to plausibly allege that the asserted trade dress is non-functional. This alone is enough to doom Cub Club's trade dress claim, but the allegations fail on the other elements as well. The complaint is devoid of allegations that the product has attained secondary meaning, and the complaint does not lead to a plausible inference that consumers are likely to face any confusion between Cub Club's product and Apple's. After all, Cub Club's product is a standalone application, while Apple's is embedded within the phone keyboard. The court reads the complaint as alleging trade dress over Cub Club's app rather than the individual emoji, but a trade dress claim over the individual emoji would fail for the same reasons. The motion to dismiss the trade dress claim is therefore granted, and because Cub Club's state law claims each depend upon the validity of the trade dress allegations, these claims are dismissed as well. The motion to dismiss is granted. Having seen many of the emojis side by side in the complaint, the court is skeptical that Cub Club will be able to allege copyright or trade dress infringement in any amended complaint. But in the interest of caution, the complaint is dismissed with leave to amend. Any amended complaint must be filed within 14 days. If none is filed by that time, the dismissal will be with prejudice. That was interesting to me to see how the court applied the Merger Doctrine without even mentioning the Merger Doctrine, but rather just mentioning the separation of the idea and the expression. And there's a limited set of expressions for how you display representations of hands and fingers and colors of skin. And since there's a limited number of expressions for the idea, then only exact copying or virtually identical copying will reach a level of copying to be considered infringement, misappropriation to be considered infringement. Copyright protection is based on protecting an original idea. You could have lots of ideas that underlie your copyright, and your protection would only protect what you brought to the work originally. So if you're drawing your own emoji, you don't have protection on hands or hands pointing up or hands making OK symbols. You have protection on what you brought to the table, your original version of that. And that's it. I thought it was a very interesting case. Let me know what you think in the comments below. I guess I can see a little bit how they would get that idea in their head that Apple had infringed. They approached Apple. They thought, hey, we've got this product that we worked on. We were the first in time to make this product. Therefore, we should get some kind of protection for being the first ones to think of this idea. Well, it's not a patent. And I'm not even sure it can be a patent. I'm not a patent attorney. I really don't know how you could patent an emoji. The different kinds of intellectual property protection, copyright, trademark, patent, and trade secret, they're supposed to be pretty much separate, and they rarely overlap a lot. Yeah, certainly you get copyright issues in making a trademark, or you might have trade secrets or something like that for patents or something, but they're not really supposed to overlap. You shouldn't be able to get copyright protection through a patent. That's not really the way that's supposed to work. So I doubt that these are patentable, although I guess the patent office will rule on that at some point. But I can see how CCI and Mrs. Katrina A. Parrott, I can see how they thought that they were wronged by Apple. They approached Apple with this idea. Apple and their attorneys probably figured out pretty quickly that emoji like this are not protectable under copyright from somebody else making their own version. We saw this same basic issue with the Lego depiction of James Concanon's jacket in the Queer Eye case, where Lego made a Queer Eye set. It had James Concanon's jacket, except Lego had redesigned the jacket so that it didn't infringe. They think it didn't infringe on James Concanon's copyright. Well, by the way, that case is still going on. They've now got an amended complaint. Concanon filed an amended complaint with more details, now alleging trademark infringement. I'm not going to go over that, but we will keep an eye on that one for you. Now that Cub Club has lost, 17 U.S.C. 505 is a fee-shifting statute in copyright, so I suspect that Apple can make a fee motion against Cub Club and get their fees returned, so Cub Club may actually owe them a bunch of money. And this may have cut severely into Cub Club's profits from making emoji in the first place. Thanks for watching. Special thanks to my top supporters in February: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Gutbrodj, Torpedan, ShadowTycho, Earthbound Star, PureMagma, TechTechPotato, Eric Tams, and the Blood-Soaked Survivors. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everybody has a great week. I love you all.